Hello, this is Matt Dickey in the Chicago office, and it's my pleasure to welcome everybody to our webinar in the Continuing Luxury and Fashion webinar series. Today's webinar, entitled Facing the Future, is going to focus on the interplay of patents, technology, and data as it relates to fashion. So to provide a high-level overview, when we traditionally think of protecting fashion and fashion goods, we think of traditional design types rights, trademark, trade dress type rights. And the first portion of this program will cover alternative intellectual property protection mechanisms such as utility patents, innovation or utility model patent rights, and design patents in the United States that as contrasted with design registrations in Europe and similar rights in other jurisdictions. Then we're going to take a look at the interplay of the transmission of data and other types of technology issues with fashion, and we have some really exciting programming in that regard, whether it be DNA as it relates to cosmetics, whether it be the transmission of authentication information via RFID and associated blockchain issues, and also looking to body scan and biometric type of data also. So without further ado, we'll have everybody that's on the call introduce themselves, all of the presenters. I'll start. My name again is Matthew Dickey. I'm a partner in the Chicago office of K&L Gates. I by trade am a patent attorney. I have a background in patent litigation, patent procurement, opinion work, due diligence, and licensing.
Hello from Berlin. This is Christiane Schweitzer speaking. So I'm a counsel and German and European patent attorney. I'm also a European trademark and design attorney. So my technical background is pharmaceutical science. So I'm handling not only the patent prosecution, but also the patent litigation part in Europe and in Germany, but also design applications and design infringements.
I'm Claude Mango. I'm a partner of the Paris office, where I'm co-lining the IP, IT, and data protection practice at the Paris office. And my claim to fame with technology is mostly personal, in that I'm a nerd and keeping a close watch on all the technical and technological development which may affect on the IT and IP side.
And my name is Corey Bieber. I'm a technology and data protection attorney in K&L Gates Chicago office. My background is I'm actually a software developer and a solution architect. I was for about 15 years prior to practicing law. And I help clients work through legal issues that arise when implementing emerging technologies. Okay, so to start us off, our colleagues in Melbourne, Alex Dunlop and Leonard Hickey, whose photo was conspicuously missing from the previous slide. Unfortunately, they couldn't join us today live. We've recorded their presentation on the topic of utility and innovation patents, and we're going to play that for you right now.
Good afternoon, everybody. My name is Alex Dunlop, and I am a special counsel in the IP group at K&L Gates's Melbourne office, and in conjunction with my colleague Len Hickey, a senior associate in our group, we've been invited to talk to you about patents in the fashion and luxury industry from an Australian perspective. So to begin with, I will pass over to Len.
Thanks, Alex. Fashion and luxury brands often rely on brand reputation and creative flair to achieve commercial success. But innovation and technology can also help fashion and luxury brands succeed by ensuring that their products resonate with and appeal to today's increasingly technologically minded consumers. For brands with a focus on innovation and technology, it's important to appreciate the role that patents play in protecting new innovations. Patents offer a robust legal mechanism to protect new innovations, which enables patent owners to prevent unauthorised third-party use of their innovations. In the fashion and luxury goods industry, patents can be used to protect a variety of innovations. For example, patents can protect new products which offer unique functional features, such as in the case of new wearable technologies. Patents can also protect new materials used to make products, such as new fabrics and novel cosmetic formulations. Finally, patents can even protect new ways to make product, such as innovative manufacturing techniques that offer improvements over traditional manufacturing. A key advantage of patents compared to other forms of intellectual property rights, like trademarks and copyright, is that patents don't, generally speaking, depend on the visual appearance of a product. This means that a single patent may be able to protect an entire range of products or even span multiple product lines. For example, in the case of a patent for a new type of compression garment technology, the look of garments made with that technology could be changed from season to season without affecting the underlying patent protection. In the same way, a patent can't be circumvented by third parties simply by changing the look of their own products. This is a distinct advantage that patents can offer compared to other forms of intellectual property rights, and another reason why patents offer a powerful tool to complement innovation as a means to achieve competitive advantage. Australia's system of patents shares similarities with the systems in Europe and the US. To obtain a patent in Australia, there are two key requirements that need to be met. First, a patent must relate to functional features of a product or process that are inventive. This inventiveness requirement applies to all standard patents in Australia, although, as Alex will explain shortly, the situation is different for innovation patents. For a standard patent, the requirement for inventiveness means, in simplified terms, that the functional features of a product or process must be something that would not have been obvious to a person having general expertise in relation to the relevant type of product or process. The other main requirements for obtaining a patent in Australia is that the functional features of the product or process must be new, meaning that they can't be the same as any pre-existing innovations. The newness requirement is particularly important having regard to problems that can arise when a brand doesn't adopt a patent strategy from the outset of their innovation journey. In particular, if a brand allows their innovations to become publicly available before a patent is filed, their innovation will no longer be considered new. And so, ironically in that case, the brand owner's own prior disclosure will preclude them from obtaining a patent for their innovation. A common way to manage this risk of prior disclosure is to ensure that any outsiders who have access to details concerning new innovations have signed a suitable non-disclosure and confidentiality agreement. This includes prospective joint venture partners and distributors who might gain access to these details in the course of negotiating new deals or undertaking due diligence. A standard patent in Australia will last for 20 years, provided that annual renewal fees are paid. The longevity of patents is, again, a reflection of their role in protecting enduring underlying functionality rather than ephemeral visual appearance. Once an Australian patent is obtained, the owner will have the exclusive right to exploit their invention and to prevent others from using it without their authorisation. Patent owners can also license their patents to third parties and secure associated royalty streams. In Australia, an exclusive licensee of a patent is given special rights compared to non-exclusive licensees. Most notably, an exclusive licensee will be entitled to itself sue third parties for infringing an Australian patent, without the involvement of the patent owner, who may well be an offshore company. For this reason, granting an exclusive licence for an Australian patent requires careful consideration and planning. I'll now hand over to Alex, who will talk more about innovation patents from the Australian perspective.
Thanks, Len. Since 2001, Australia has had a second tier of patents, which are called innovation patents. There are a number of differences between innovation patents and standard patents, which make innovation patents especially suitable for protecting incremental developments in products that do not meet the standard of inventiveness required for standard patents. One way to think of this is that innovation patents protect iterative developments as opposed to hallelujah moments. Firstly, unlike a standard patent, an innovation patent only needs to have an innovative step compared to what has come before. This has been assessed in Australia as being a very low standard and a low threshold to be met. Secondly, the exchange for having a lower threshold is that the maximum term for innovation patents is only 8 years rather than the usual 20. This makes innovation patents an obvious choice for shorter-lived products and so lends them to greater utilisation in the fashion industry. Another point to note about innovation patents is that they can only have a maximum of 5 claims, whereas standard patents can have an unlimited number of claims. Fourthly, the innovation patent system has been designed to make innovation patents quick and affordable to obtain. In the case of a standard patent, once the patent is filed, the applicant must wait a significant period, which is usually measured in years, before the patent is examined. In the case of an innovation patent, there is no substantive examination when the application is filed, meaning it becomes granted within around a month of filing, after a formalities review only. The owner of that innovation patent then has a valuable registered right, which it can license or use to attract investment. An important reminder, however, is that if the owner wishes to enforce that patent against a third party, they have to request substantive examination, which, if successful, will result in the innovation patent being certified. That process typically takes around 6 months. However, as I've mentioned earlier, certification is only required for enforcement against a third party. It is entirely possible that an innovation patent will go through its entire 8-year life cycle without ever being certified. Finally, draft legislation has been prepared and put before the Australian Parliament, which, if passed into law, would result in the eventual phasing out of the innovation patent system in Australia. We would describe the timetable for the phase out as being relatively generous, but would still encourage businesses thinking of using this system to do so sooner rather than later. On the same note, while innovation patents are still available in Australia, we encourage our clients to consider using them as a quick and cost-effective method for protecting their inventions, particularly those inventions which may be considered to be an iterative advance over what has come before. That concludes the end of the Australian section of this presentation, so thank you for listening in. As this has been pre-recorded, if you have any questions that arise from the matters Len and I have discussed, we'd be very happy to hear from you via email and answer any questions you have. Thank you.
So in furtherance of that component of the presentation, and thank you to our Australian colleagues by recording, Christiane is going to transition to a discussion of European utility patent protection and move into German utility model patents in contrast to Australian innovation patents. Christiane?
Thank you, Matt. So we are now in Europe, and we do have a European Patent Office, even though this is not connected to the European Union. As you can see from the map, the protection for a European patent is broader than just the country scope of the European Union. So we have 38 member states of the European Patent Office, inter alia Switzerland, Turkey, almost complete Eastern Europe, and Iceland, for instance. So the patent protection itself is very similar to the one of in Australia or US, so meaning the patent can only protect inventions which are novel and inventive. And it has the option to protect a product by itself or a process to produce a product, or even a use of a known product or composition which is of special interest for, let's say, cosmetics. As I said, the country scope for the European patent is quite of interest, and the examination proceeding is just one examination proceeding before the European Patent Office for all 38 member states. Once the patent application is ready to grant, you have to decide as an applicant where your protection should be validated. So you have to make a decision on a country-by-country basis and validate your patent then on every single country of these 38 member states. But you don't have to have all these states. You can make a choice. Once you decided that, you can enforce your European or your national part of the European patent on a country by country basis, where Germany, UK, and France are the countries of most interest, as the judges are most accepted. What I wanted to mention is that we have a second, a similar protection right in Germany, for instance, which is similar to the second-tier patent in Australia, as we heard. And I just refer to the German utility model as an independent IP right, even though this is a similar right, which is also available in other jurisdictions, like in China or even in other countries in Europe. But the German utility model is very famous, as it is at very low cost, I have to say, so just few €100, and it's registered without any substantive examination within 2 to 3 months. And the protection is quite similar as for a complete European or a German patent. So the only thing you cannot protect with a German utility model is purely method or process claims. But any other product or composition or even uses are protectable by a German utility model. The term of such a German utility model is 10 years, so the maximum, and it's fully enforceable against any infringement in Germany with all the claims you have for a patent too. So it's a damage claim and injunctive relief, and you can also claim for elimination of the infringing product itself. I'd like to hand over to Matt again, and I think we start in the US again.
Yes, we'll transition our discussion, thank you, Christiana, to design patent rights. And in a moment, Christiana is going to contrast these rights with what you would think of as traditional design registrations. So in the United States, we actually have what's called a design patent, which is an often overlooked mechanism for protecting the ornamental design of a functional item, in contrast with a U.S. utility patent or Australia, Europe, any jurisdiction, which protects the way an article is used and how it works. So a design patent is similar to the concept of a registered design, except the confines of it and the examination mechanism is more similar to a U.S. utility patent. A design patent is a series of figures, which are the claim, which in a utility patent is the sentences you see at the end of the patent describing the function. The claim of a design patent is the ornamental images of the product. The design patent is examined for novelty and non-obviousness. So basically, the patent examiner determines if there's a previously existing design that looks exactly like the figures. And if it issues, it will have a term of 15 years from the issuance of the design patent. And unlike utility patents, there are no maintenance fees associated with the design patent. Once it issues, then those rights are in place for 15 years with no further fees. Just as U.S. utility patents, there is a 1-year grace period from public disclosure. As many of you may know, the U.S. is not an absolute novelty country. So for both utility patents and design patents, if there is an inadvertent or intentional public disclosure, you still have 1 year from that disclosure to seek the design patent protection. This design patent application is going to be much cheaper than a U.S. utility model patent application. We're looking at, I believe, on the order of $900 as opposed to $1,700 or $1,800 US dollars. And also the examination is going to be quicker, and there shouldn't be as much back and forth with the patent office. There's also a mechanism to limit what's actually being claimed. If you pull up a design patent on a patent search site, you'll see phantom lines or dashed lines in some instances. That means that that particular component is not supposed to have patentable weight when you're considering the design patent. So you could claim the the overall appearance of the item, but then maybe certain functional items or certain aspects of it you don't want to claim. So those elements will be shown in phantom or dashed lines. I'm just going to focus on just a few recent developments in U.S. Design patent law, most notably of them being damages, the last one. A complicated interplay in the U.S. between design patent rights and utility patent rights is in a design patent, you're not supposed to be able to protect function, but ornamental appearance. Accordingly, there's traditionally been some dispute in design patents over whether functional mechanisms illustrated in a design patent should actually be given weight. So this could be a clip, some sort of an attachment mechanism, and there's recent case law that's made clear, as long as the design is not primarily functional, you can still protect designs that have functional purposes. So a perfect example is if you think of a belt buckle or something like that, that's a great example where the appearance of the design, even though it has an underlying function, it's still unique and you're still protecting the ornamental appearance of it. Shoes are another big, particularly tennis shoes, athletic shoes are another big area where U.S. design patents are used. There's recent authorities suggesting that as long as the appearance is clear, you can use a two-dimensional drawing to disclose a three-dimensional design. And in this case, it was the sole of an athletic shoe that was shown in a two-dimensional plane, and the court determined that you could still construe what the design would look like in 3 dimensions. Importantly, damages. Probably the most notable design case involving design patents recently in the U.S. was the Apple-Samsung litigation, which included utility patents and design patents. And this was basically the battle of the iPhone versus the Samsung Galaxy phone. And one of the components was design patents. And ultimately, Apple, even after this went back down to a jury on damages, ended up receiving $539 million. One of the key questions was whether or not the design patent should be attributed to the whole profits of the phone. Statutorily, the damages for design patents is lost profits, whereas utility patents, it's lost profits or a reasonable royalty. So that's a big deal. Design patent damages can be very lucrative in the United States. And in this case, the matter was sent back down to the jury under a standard developed by the appellate court to consider whether a design patent on a particular component of a product should drive lost profits for the whole product. So the jury was instructed to look at the overall scope of the design patent, the relative prominence of the claimed design within the product as a whole, whether it's conceptually distinct from the product as a whole, and the overall relationship, including whether or not that should be offered independently. So in this case, the jury did decide that Apple should be awarded damages on the full profits of the device. So now, without further ado, I'm going to turn the presentation back over to Christiana to contrast the U.S. design patent right with European design registration.
Thank you. So such an important case as for the Apple watch this is also a big issue in Europe. So European design registrations are quite famous here too, and we're now talking about Europe as we know Europe. So we're talking about the European Union Intellectual Property Office. This is not at all related to the European Patent Office. So you see now a different map with a different, not different countries, but a different country scope. So we have 28 member states of the European Union, which could be possible to be registered for a European design. So what is protectable in Europe? It's more or less exactly the same as in the US. So you have to have a specific appearance of either part or the whole of a product, and this appearance cannot be based on such a purely functionality. It has to be something special, let's put it this way. So if you think about, let's say, a transdermal patch for medicines, even this is open for design registration if this is designed in a specific way, not only driven by its function. But a typical design for Europe would also be a fancy Vuitton shoe or car wheels or, the Apple Watch. So you have two choices to get a European design registered. You can either just stick with the unregistered community design, which has a protection of 3 years automatically with its existence. This is limited with the scope of protection, but not by the country scope. But more of interest is the registered community design, where you have a protection of at least 5 years and up to 25 years of protection throughout complete Europe. So the protection is for the complete line of launch of a product. So it's the manufacturing, the market launch, an offer for sale, product marketing, and even the importing or exporting through Europe is protected by such a design. You might be interested in the differences between a European design protecting complete Europe and a design available on a national basis. And just to compare it with the German design, I mean, the benefit of having a European design is that you have just one design for complete Europe. On the other hand, if your European design is attacked and revoked, it is also revoked for complete Europe, which makes this really makes a difference compared to national designs. Let's say you have 10 national designs in the 10 most important markets in Europe, and all of them would have to be revoked on a national basis in several court decisions on several bases. So this is that is a benefit and a downside at the same time. The good thing about the German designs is that having a German design registered and published, you automatically have the additional unregistered community design for Europe for 3 years automatically. So with that, I think we come to an even more interesting topic.
Okay, so next we're going to discuss rising tech trends and how they interplay with the luxury fashion industry. Specifically, we'll cover blockchain, DNA, customized cosmetics, and body scanning for bespoke clothing. But we are going to start with blockchain. So I wanted to give you a quick primer on blockchain and distributed ledger technology and some of the applications we've seen of this technology among our clients. And I'm going to try to do my best to keep what can be a highly technical and esoteric subject simple to account for the varying degrees of technical knowledge that we have on the phone. And then my colleague Claude Etienne will go into detail on how blockchain is being applied and can be applied to the luxury fashion industry. So we're seeing a lot of clients in a lot of industries, manufacturing, communication, retail, the list goes on, talking about blockchain and the appropriate use of blockchain technology. Importantly, there seems to be a consensus that this is something we can help drive innovation with respect to cost, quality, and efficiency moving forward within and between the industries. But first and foremost, what is blockchain? I think the best way to approach the definition of blockchain is to understand the problem it was designed originally to solve. One of the original functions of blockchain was to build on the concept of the ledger Effectively, blockchain is a distributed ledger that can be either public-facing, like Bitcoin or the financial blockchains, or private-facing, like the K&L Gates blockchain, which we have internally. Historically, by which I mean about 2 years ago, a business transaction, you typically had each party maintaining their own copy of a ledger. And when a transaction is conducted, each of the parties updated their own ledger. Alternatively, they could rely on a trusted third party to maintain the ledger. Whereas this is how business transactions have taken place for centuries, the process is inefficient, duplicative, prone to mistakes, and vulnerable to fraud, malicious modification, and potentially cyber attacks. Blockchain solves for this by building a single ledger that is replicated across a peer-to-peer network, so you have one system of record. At its core, a blockchain is a series of blocks, which are programmatic bundles of transactions, be it financial or business. The blocks are then chained together and distributed across multiple nodes or network participants. So this could be different companies or companies within the same industry, or even offices within the same organization. In terms of the value of blockchain, it provides 4 core properties. Those are consensus, provenance, immutability, and finality. Consensus allows us to programmatically, within the blockchain, determine who within a transaction can validate or approve the transaction. And this is known as selective endorsement and is really applicable to the business applications of blockchain, as opposed to the financial applications, which really aren't the subject of what we're talking about today. Provenance is the audit trail that allows us to establish who owned what, or who did what, or where what came from as a transaction progresses by loading the activities and ownership of the individual parties into the blockchain. The blocks containing these activities are linked together using privacy services to prevent tampering, which makes them immutable, which is another principle of blockchain, and which establishes the trusted network that we're looking for. And finality, the final principle, is really a combination of the first 3 properties, where once we've committed a transaction to the blockchain, we have a single trusted ledger, which makes disputes relatively easy to resolve. And I'm going to hand it over to Claudia.
Thank you very much, Corey, and hello, everyone. So over the past decade, the mystics surrounding Bitcoin and the underlying blockchain technology has been the topic of many half-truths and fantasies of so-called revolution in various industry sectors, starting with finance. However, in order to move forward from the general theory to a more applicative approach, we will focus on a very practical example in the luxury sector, and that reduction to practice is also tying a loose end with the patent presentation that preceded that. Namely, this is the use of RFID technology, which is already included in several luxury goods for various purposes, such as supply chain management or anti-theft within the stores. So you already got that technology embedded in the good, and what is being added is an application layer of a certificate of authenticity that is stored on the blockchain. So, as Corey just exposed, storing that certificate on the blockchain allows many interesting use for that technology in terms of immutability and finality and provenance. And the reason why this is becoming something of importance in the luxury sector is that it would allow the owner of a luxury good to check immediately and regardless of the actual channel of provision of that good, whether the said good is authentic or not. And this has been notably announced by Louis Vuitton 2 weeks ago, launching a product called Aura alongside Microsoft and Consensus, using not the Bitcoin blockchain but the Ethereum blockchain, which is a permission version of the Ethereum blockchain called Quorum. The application to the fashion industry provides for many interesting outcomes from an IP point of view, as it empowers the customers with regard to the good that they can be acquiring, either as a primary acquirer or secondary market, and it will limit the annoying dissemination of counterfeit, since it empowers them to check prior to the sale whether said good is authentic or not. There is no excuse for them not to validate what they're actually purchasing. And from a commercial point of view, this is something that raises brand perception in terms of technological acumen and finger on the pulse, but also brand protection, as it allows better control over the market and the dissemination of the good. It's also an interesting aspect with regard to the access by brands to a secondary market that, strictly speaking, has been evading them. When a customer is in a store, it is easy to reach them for CRM purposes. However, when the primary acquirer is reselling that good on secondary market, this is something that is very difficult for brands to reach out. And having that authenticity certificate validated over the blockchain and tied to another layer of customer care would also be a good way to reach out to that secondary market. However, this is not without any issue with regard to the legal aspects. Not only we'll discuss that about privacy, but jurisdiction issue or smart contract, which, even though it's not the topic of today, is something that is relying over the blockchain. But what is interesting with regard to the Vuitton solution is that a blockchain, by essence, is something that is multi-stakeholder, and it's usually brand agnostic. And in order to do that, this is a solution to become market standard. And if all authenticity solutions are embedded over the same blockchain, that will allow cross-pollination and dissemination of the technology. And on that, back to Corey.
Okay, so a question we get most frequently is, how does blockchain work with the existing laws that we have in the U.S. and in the EU? And I can tell you that in the U.S., with respect to the law of contracts, e-sign, the state electronic signature laws, and generally regulatory compliance, the blockchain technology is really not at odds with those laws. In fact, in many ways, some of the e-signature and digital signature softwares that are available today are starting to incorporate blockchain into their technological solutions. Now, in terms of privacy laws, there's a problem. In particular, in the EU, with the GDPR, the concept of immutability is not really congruent with the EU data subject's right to be forgotten. Also, there are jurisdictional issues. With data is truly distributed, what jurisdiction applies in terms of controller-processor relationships in a distributed network, who is considered a controller, who is considered a processor. These are all issues that we're still trying to work out. And I know that some of the data protection authorities have put out guidance, but I don't think there's consensus right now in terms of how we should approach this. In the U.S., in terms of privacy laws, as you may be aware, there's a patchwork of privacy laws here. The most stringent privacy laws in the U.S. are out of California, the existing laws, and our upcoming California Consumer Privacy Act, which is going to give similar data rights to California residents as the GDPR gives to EU residents. And included among those rights are the right to erasure or the right to be forgotten, which again is a little bit incongruent with the concept of immutability that we see in blockchain. Okay, so benefits and drawbacks of blockchain. Good and bad, right? So we see that it saves time, increases trust, traceability. These are all foundational principles of what we see when we talk about the concepts of immutability, security, these sorts of things. In terms of issues, it's harder to fix errors It does not, as we said, remove all of the privacy concerns. And the concept of overbuild is really something I want to talk about. This has been dwindling slightly, but at the beginning of last year, we were seeing a lot of clients come forward with, well, how do we incorporate blockchain into our business model, which really isn't the right way to approach it. If there's a need for blockchain, then the solution, or if there's a need, blockchain may be the solution. I found that a lot of clients were just trying to implement blockchain for the purpose of implementing blockchain, so they could say they could for marketing purposes or whatever the case was. So it's not always necessary to accomplish what the needs are of the business, and I think there has to be a careful evaluation as to whether or not it's appropriate technology in all cases. And I will pitch it back over to Claude Etienne.
Thank you, Corey. And we're switching to another topic that has stemmed from progress in genomics and expiration of a certain patent that made DNA testing and the cost for analysis drop over the time. And what has happened over the past couple of months or up to last year is that cosmetic companies have been able to provide on-site DNA testing, not for the whole genome, but for specific genes that would be in their customer, and determine what gene does what and who has that variant of a gene in order to provide bespoke cosmetics to them. So for instance, if you got the gene for a certain skin characteristic, then you'll respond better to another cosmetic cream, for instance. And this is a specific issue, especially in Europe because of GDPR, but as most of you should know, GDPR also have an extraterritorial reach. So the mere fact of providing or offering services to European residents or monitoring European residents, even though you would not be established in Europe, could expose you to the reach of GDPR. And under GDPR, there are personal data, but there's a special category. There are special categories of data. Among them is genetic data. The use of DNA, because it's intrinsic to a person, may result in high risk if it's poorly handled or if there's a data breach. It's even more sensitive given that is something that cannot be changed by the data subjects, unlike an email address or a phone number. So one of the safeguards that has been implemented under GDPR is the request of consent. This is not the usual consent that was under the Data Protection Directive or maybe construed elsewhere. It has to be a very specific, informed, and freely given and freely revocable consent. In that sense, Google was fined last month for 50 million euros in France over the use of a consent that was not deemed valid under GDPR. In addition, because of the high risks that are presenting to the data subject, any entity that would be providing such a DNA customized cosmetics would be mandated to perform a data protection impact assessment prior to implementing that processing. So that would be doing a complete analysis of what you're intending to do, how you will do it, but also study and preview any worst case scenario, how you're trying to mitigate that and remedy any adverse consequences that would arise from that worst case scenario materializing. But in addition to that, this is the European framework, and because it's a regulation, it's more or less enforced in a harmonized fashion in all 28 member states. But DNA has not awaited GDPR to be used, and there are strong member state laws at local level that may also restrict the use of DNA. So, for instance, in France, DNA testing is restricted under the criminal, the civil, the public health, the defense, and entrance of foreigner codes. It's a civil law country. We really like our codes, and such general prohibition requires that the use of DNA fingerprints to identify either a person itself or its characteristic, which would be the case for DNA cosmetics, which would be done without supervision from the judiciary or under the initiative of the police, is triggering fines up to 15,000 euros or 1 year of imprisonment.
Okay.
And
so
back to court.
Oh, yes. Thank you. In the U.S., again, when it comes, we have not caught up with the technology when it comes to the use of DNA data in commercial practices, and we have a number of different laws that may or may not apply to different levels, and we also have a number of different concerns that I think are well-founded, and I want to go through some of these. So DNA is typically used in forensics and law enforcement. We do have laws that establish that it can be used for these purposes, and quite frankly, there's a realistic concern, and this is something that's been presented in the media recently. If your DNA is stored by a commercial company, to what extent can law enforcement compel the company to turn the genetic data over to the law enforcement agency for whatever purposes that they need it for? So that's something we've seen bouncing around a lot, and it's uncertain right now as to where the law starts and begins with respect to the ability to subpoena that data from commercial entities. We do have the Genetic Information Non-Discrimination Act and its California corollary, which is GINA and CalGINA. This really applies to insurance companies and employers, and it's designed to allow them, or to not allow the employer insurance company to discriminate against individuals based on genetic data or access that information because it could be used for the purpose of discrimination. However, again, it's not really broad enough to cover commercial companies that collect genetic data, and there's all sorts of issues that could arise out of that would not be covered under GINA. Again, the California Consumer Privacy Act, which goes into effect in 2020. One thing I would like to say about it is January 1st, 2020 is the date that the CCPA is supposed to go into effect. The AG has been given extension on rulemaking to June of 2020. So there is a lot of confusion as to where the CCPA applies, how it applies, and what exactly the language means. However, in the definition of biometric information, it is clear that DNA is included, which would mean that the rights and privileges that come along with, or the data subject rights and privileges that we see coming along under the CCPA would be applied to this data. And we're seeing the right to notice, the right to request information from companies. So what categories of information are they collecting? What third parties are they sharing information to? For what purpose are they using the data, in this case potentially DNA data? The right of access and the right of deletion we're seeing as well. One thing that's important to understand about the CCPA and why we need to pay attention is there is a private right of action with respect to data breach and violation of the Act. However, with respect to violation of the Act, there's a 30-day notice requirement for anyone who would be filing an action, and the business has the opportunity to cure their violation within 30 days. So that's just something important to remember. Private right of action is an issue. We've seen a flood of litigation in other areas involving data protection, such as biometric information, which we'll be talking about shortly. And then another thing companies need to be aware of is often in the U.S., their practices with respect to privacy of information are governed under their privacy policy. The FTC enforces this under Section 5 of the FTC Act, which prohibits unfair and deceptive marketing and trade practices. And we would expect that issues with respect to the collection and use of data, which would or could potentially be approached under the FTC Act. And I will hand it over to Claudia Etienne.
Okay, so the last topic we wanted to quickly address is intended to be a silver lining because we saw a lot of hurdle and drawbacks to potential projects, but there's also some misconception about GDPR, notably the body scanners that have been made very central to public eyes courtesy of TSA. and perceived as overly intrusive in terms of security measures by revealing intimate details, are also used now ahead for the provision of bespoke clothing or custom 3D printed accessories made to measure. Indeed, the use of such body scanners or depth perception camera allows to take very precise measurement of a person, and by as such allow the provision of highly tailored items. And this resulted from a conference I attended a couple of weeks ago, where these measurements has been construed as belonging to another special categories of personal data under GDPR, which are biometric data. However, if you look closely, the biometric data are only a special categories in as much as they are used to allow confirm the unique identification of a person. However, if you use that for commercial service without any identification purposes, then it will not require consent. It will not be considered a special category. However, because the line is tenuous, the data protection impact assessment that we mentioned before, that is only mandated where there's a high risk to personal data of the data subject, will be mandated. If not for anything else, it will be to showcase that there is no high risk and that it's indeed not to be construed as biometrics data used for the purpose of identification of the data subjects. So in our opinion, this is probably the least problematic of the new trends in technology in the luxury and fashion sector that we've seen arising the past couple of years.
Okay. So similarly, in the U.S., collection and consent for collection and use of biometric information is a hotbed of litigation, in particular in Illinois. But similar to the EU, the majority of the statutes that we see have the qualifier that the data is used to identify an individual. In the case of bespoke clothing, that's not necessarily what's going on. Again, there's one exception here, and that is California. Again, this law doesn't come into effect until 2020, but the California definition of biometric information says that can be used, so not is used like it is in Illinois, Washington, and Texas. Texas isn't on this slide, but they also have a Biometric Information Privacy Act. So in terms of the U.S., I think we have to pay very close attention to how courts are interpreting biometric identifier, biometric information, and how they're applying the law in these areas. But as the law states, as the black letter law states today, it does not look like in Illinois, Washington, or Texas that we would have too much of an issue with collecting this information. However, consent is always kind of the safest path to go. And that being said, question and answers.
If anyone does come up with any questions, please feel free to reach out to any one of us, and we'll be more than happy to answer your questions and continue these discussions. And with that, this will conclude this program. Thank you.